a defendant's appearance in court is their promise to do so. The judge can also require a defendant to post a cash bond, i.e. the judge could set a bond in the amount of $1,000 with 10% due, meaning the defendant or their family would have to post $100 to be released pending trial. The judge sets the cash bond, can set that cash bond in any amount. When the defendant comes to court and the case is resolved, that person gets back $100 minus 10% processing fee, so about $90 back on that bond. In addition to an ROR or a cash bond, a judge can require other conditions of release. Some examples include the 24/7 program, which is a daily drug and alcohol screening. The 24/7 program is used in drug and alcohol cases to ensure that a defendant abstains from the use while out on bond. What this bill does is twofold. It would eliminate the cash bail and replace it with other tools the judge could use to ensure safety of the community and any alleged victims, preservation of evidence, and ensure the appearance in court while not holding the defendant unnecessarily in jail, causing them to lose their job, their house, or progress in school or treatment program. I brought this bill because it's an important conversation to have, particularly in the wake of last summer's protests. This committee heard hours of testimony from Nebraskans who believe that our criminal justice system is broken. Many of those same people took to the streets to protest police brutality and were met with mass arrests. Many held in county jail, forced to pay bonds for minor offenses on arrests the city later had to acknowledge were not justified. The highest levels of the city government took an interest in an organized payment of those bonds, as recently was disclosed by the ACLU. I have appeared before this committee on a number of times this year on criminal justice bills, and I've drawn on my experience in the Douglas County Public Defender's Office to inform my perspective, and I can tell you that the cash bail system, as it currently exists, penalizes poor people. Defendants who cannot afford bond may take a guilty plea to avoid more jail time, even if they have a valid defense. The system right now bears no relationship to the likelihood of appearance or the danger to society. It's only a measure of access to capital. I'm a believer in reforming the system where we can, and I recognize the difficult fight we often have in this body to even get modest reforms passed. So I know that in this light, LB636 is an ambitious proposal, but I think it represents a statement of purpose. People should not face jail time solely because of their inability to pay. Under this bill, a judge could set conditions of release that actually bear a relationship to the reasons bail exists. On a recent day in Douglas County, the jail there had 1,176 humans being held there. 988 of those people were held pre-trial, meaning almost 1,000 members of our community were in jail and they had not yet been convicted of a crime. They were still innocent until proven guilty. I'm sure it didn't feel that way to them, as they are currently being deprived of their liberty. This isn't unusual. The vast majority of people in Douglas County Jail are not serving a sentence. They're awaiting trial, and as an aside, jury trials have not been an easy thing to get in the last year. You'll see there's a fiscal note that estimates a $1.9 million to $2 million impact to the general fund from the loss of cash bonds. This money comes from that 10% off the top of each bond posted. I want to stress that relying on the denial of a person's liberty as a revenue source for the state is not a policy I agree with. I'm willing to continue this conversation going forward. I want to thank the committee for your time and your hard work and attentiveness through this session. And as I said, I've had quite a few bills before the Judiciary Committee, and I appreciate the back and forth we've had on all these bills. I would appreciate your support on LB636, and I'd be glad to take any questions at this time.
Okay. Senator Brand.
Thank you, Chairman Lathrop. Thank you, Senator Cavanaugh, for bringing this bill. First question, on the fiscal note, they're estimating a $2 million reduction in revenue, which would obviously be the bond that's paid. Who gets that money today? Does that go to the county or the state or the judicial system?
I think that goes to the judicial system. I actually printed that out. I wasn't quite certain on that either, and I looked it up. I think it's referenced in 29-901, but it goes to, I think, a judicial cash fund.
Second question. On those 900 individuals, and I remember this from 2 years ago, I believe this bill was brought by somebody else. So we've got somebody that's in for some petty offense, public something, and maybe you could fill in the blank on that. And they're in jail for 14 days. And do you know what the cost is to incarcerate somebody like in Douglas County Jail? Is it $100 a day or $70 a day?
I actually couldn't get a hold of the Douglas County number. I know the Lancaster number is $110.
Okay, so let's say $100 a day, and they're in there for 14 days, and so it cost somebody, whether it's the city, county, or state, $1,400, and then they go to court and they have a fine of $100.
That,
And
yes.
so do you have any cost-benefit ratio on, we should be able to figure some of those numbers out, should we not?
We could, and that's, I appreciate, thank you, Senator Brand, for that question. I appreciate it, and I appreciate that perspective. And yes, we are, and there's a couple of other layers to what you're talking about. So the example I often think about is the number of people in Douglas County Corrections who come through on trespassing at, say, the Sienna Francis House at a homeless shelter. They get arrested, they go to county jail, they can't post bond, they end up, sitting, for a week or so on that. But the other example, kind of what you said, was you could go, somebody maybe could ultimately get out. They could get arrested on a Friday, get held until they go to court on Monday, get released, and then get sentenced to a fine, and then go ask to sit out that fine. And then, again, we'd be paying for that. So there's a lot of that kind of cost that we bear as a society for that incarceration. But ultimately, to answer your question, it's going to depend. So the purpose of this bill is not to say there's 988 folks being held pretrial in Douglas County and that they're all going to be released, right? It's to create a structured system under which they would be assessed for their risk, and then the conditions of release would be proportional to their offense, their risk, the risk that they pose to society, the risk they pose to the individuals, and all those other aspects. And there would be a wide range of those available resources. So not everyone would be released, and so it's kind of going to depend on like how implemented. But I think in the fiscal note you can see that Lancaster County presented how much money we would save on a change of 100 people or 200 people, which is substantial. I'd have to pull it out here, and actually we have Mr. Nigro is, I think, going to testify as well. But if you look at the savings, they estimated a savings of $1.3 million, I think. See, 2 years ago, Lancaster County estimated savings of $662,000 if the jail population was reduced by 100 inmates. And so, that's a change of 100. And again, one problem we have is we don't have good data. We can't tell you exactly which ones. I can tell you, based off of the Douglas County information, of the 988, about 800 and some of those were in on felonies, and about 100 and some were in on misdemeanors. But again, those are all pre-trial detainees in Douglas County.
And that sort of segues into my last question, and you may not know this. If we have 1,000 people in jail, what percent of those people are eligible for bond that don't exercise that right, which probably is the people that can't afford it?
Right. So the question is, everybody is eligible for bond with few exceptions.
Okay.
So there are, under our Constitution, everybody is entitled to have a cash bond set, essentially, with the exception of people held on homicides and then certain sexual offenses. And so anybody else would have some amount set, and whether that is from that $100 or, well, $1,000, 10%, up to $1 million, which means you'd have to post $100,000. And that is most of the people who are in Douglas County Corrections pretrial are sitting there on an unpostable amount of cash. And whether that is, and the likelihood of their ability to post is going to be proportionate to their basically their access to capital, right? And so that's effectively means, and the reason I'm bringing this bill is for those folks, if your bond is $100 and you can't post it, you are exactly the same position as if you are unable to, if the court determines that you can't safely be supervised in the community. And so we have made dollars a stand-in for safety, because it's easier to say, this is what risk I think you present, and this is the value I place on that. This system just says we're no longer going to consider dollars as that stand-in. We're going to actually consider measures that we can take for that community correction. And so it's just a more thoughtful approach, I would say.
Thank you.
Senator McKinney.
Thank you. Senator Cavanaugh, I'm sure today we're going to have some individuals come up and say that if we in cash bail, we're just gonna let violent people out on the street. But like you said, there would be a risk assessment. I'm curious, do you trust the judgment of the judicial system to correctly assess these individuals prior to allowing them back in?
So you're asking if I trust judges to use their judgment?
Right.
Thank you for the question, Senator McKinney. I'm not going to answer that as candidly as probably some people would like. But I think that if we create a system that is as robust as this, which includes an objective assessment that will be performed, and then the judges have a wide variety of skills. Or wide variety of tools. One, you're taking the discretion to incarcerate or not incarcerate more or less off the table, because it makes it harder for them to determine to hold somebody. Because right now, a judge can say, in my judgment, this person is a risk valued at $5,000. And that makes it easier for them to say, well, I'm allowing him to get out. I'm not saying he can't get out. I'm just saying he'd have to post $5,000 to do it. And that's basically an easy way out for them, right? So this makes it a little bit harder, and they have to put some a little bit more effort into their explanation if they're going to hold somebody. And again, that person then, the one thing we didn't address is that person would then get to come back again and say, well, here's a different, other way I could be supervised in the community that would be more restrictive and therefore less necessary for me to be held. So you can have a little bit more back and forth that's not just, well, now I've got $500, can you lower it to $500, as opposed to the conversation, that's where the conversation goes in bail situations a lot, is the judge will say, I want you to post 1,000, a defendant will say I can post 500, and the judge will say, okay, 750, which is effectively no different than 1,000. So I think that when we go to this style of system, we are going to have to do some educating, and I know that actually is part of the fiscal note from the Supreme Court. But I think that it'll be a learning curve for sure.
All right. I looked online to see what other states or cities were doing this, and I saw that in D.C., 94% of the defendants on pretrial release, 91% of them returned. So it's not like these individuals aren't going back to court. My question is, in your experience, is it easier for an individual to fight a case in jail or outside?
Oh, it's certainly easier to fight a case outside. And it's easier, I guess I don't like that characterization. It is easier to assert your rights when you are out of jail than it is when you're in jail.
But is it also, because I know a lot of times individuals sit in the county jail and they sit there for a long time, and the county attorneys or somebody keep coming to them to get them to take a plea deal, and after sitting in the county for a long period of time, some people just give up the fight and say, whatever, I'm going to cop out to this plea just to get out of here. Do you think that with this in place, people would avoid doing that as much? Yes, I think one of the intentions here is it removes what I would consider an artificial reason why people would accept a plea deal. The problem you identified is where sometimes a lot of people will plead for time served, and rather than fight it at that point. And they will sit for 60 days, 90 days, 6 months, depending on the offense, and then plead for time served, get out, and the penalty at that point is having a conviction on your record because you get to go back to your life. If we did this, obviously not all of those people are going to be sitting outside during that time because they would still have to pass the assessment and be found to be supervisable on the release. But it would decrease the number of people who are sitting there who otherwise are only sitting there because they can't come up with $1,000. And so it would rebalance that in that way. Thank you.
Answer that question.
Senator Pansy Brooks.
Thank you. Thank you for bringing this bill, Senator Cavanaugh. I have the pages pass out something to you, and it's written testimony in lieu of being here and present. And so I don't think they're going to be here. I don't know, unless I don't know somebody here. But anyway, I just wondered if you could speak to a few of those bullet points that are there. I could read them, but they're saying that failing to account and advise the court on criminal history and defendant's local ties and failure to appear record may violate ethics and court rules and deprive court of opportunity to preside over fair judicial administration of law. Do you have a comment on that?
Failing to fully advise the court of criminal history and defendant's local ties and failure to appear record may violate ethics and court rules. I don't know how that violates ethics. And the court rules really are, I guess my interpretation of court rules would be their interpretation of our statute. And so if we changed the statute in such a way that said that they couldn't consider certain things in bond, that's our instruction to the court that should be integrated into their rules. So I don't really see that as an issue. I mean, I take issue with the necessity of that information being relevant to a bond, but.
Okay, so then the next one is that they're saying that the number of individuals who will fail to appear will far exceed tens of thousands who are currently on warrant. Do you want to speak to that?
I'd like to see that number of the tens of thousands who are currently on warrant and what that means.
Tens of thousands.
Right, and whether that's in one county, if that's the state, if that's a national number, and whether those are failure to appear warrants. I would take a lot of issue with that, but as Senator McKinney kind of pointed to, in a place that has a good experience with this, which is the District of Columbia, they have a small failure to appear rate. So I think that's, I would have to see the numbers that they're referencing to make an actual comment on that.
Okay, and then they talk about catch and release policies in other states have had disastrous results, that those on recognizant conditional release or no cash bond have little incentive to appear and needlessly place the public at harm. Do you have a comment on that?
Yeah, so.
And violent crime rates have rocketed, they're saying.
And I appreciate the county attorneys bringing up that point. The difference here is, and I don't know which states they're talking about. Again, this is, they didn't cite any of their work on this, I guess, so I couldn't specifically rebut where they're getting their information. But the difference is, we're making an assessment about whether or not this person, individual, that you are releasing is actually a risk, and then we are putting specific constraints tailored to that person to ensure that they are going to refrain from criminal conduct, that they're going to show up, that they're not going to present a risk. If the only constraint on somebody's liberty is cash, if you have cash, you can get out and do whatever you want. And there's countless examples of that under our current system where the judge set a bond that they thought was high enough to keep this person in custody, because they did that on purpose to set it at a level that they didn't think they could get out. And that person made that bond and then went and did something atrocious. What this system would do is say, well, we don't care how much money that person can post. We think they present this type of risk, and we're going to mitigate that risk in these specific ways. So it really would address those specific concerns. So I don't know what jurisdictions they're talking about or what action those jurisdictions have taken.
Okay, and then it talks about no cash bond would result in persons being held for trial without opportunity for release on bail by sufficient surety, and it would violate the Nebraska Constitution.
So, and there's actually somebody who maybe can speak more eloquently to that who's going to testify after me, and so maybe I'd just defer to that.
And then finally, individual civilian pretrial release employees to supervise violent felony offenders or habitual absconders raises innumerable concerns, including civil liability.
I guess I don't know what to say to that. It's involving civilian pretrial release employees to supervise felony. We already have civilian programs that supervise people, and if there are people who are violent, again, they may have a very high level of release, or they may not be released. If they're habitual absconders, I don't know. Their definition of habitual absconder is probably going to be different than my definition of habitual absconder. But if it is somebody who really is going to flee the jurisdiction, they probably would have a pretty high level of supervision as well. there are, opportunities in this for ankle monitor, and there's opportunities for daily check-ins. There's opportunities for all kinds of levels of supervision here that would address those specific concerns.
My little tiny bit of experience with this was that our daughter, Avery, got to work with the ACLU and go in, people were unable to pay their rent. Their families were losing their homes because they couldn't get out and go to their jobs. I mean, it is not, it's so shocking when you learn, one of the first things you learn in law school is, the debtors' prisons are illegal. And when somebody can't pay their bond, that's basically debtors' prison. So anyway, thank you for bringing this bill.
Thank you.
I got a few questions for you.
Okay.
And I mean that literally. Does Douglas County use any kind of a risk instrument or any objective measure for the risk that someone will not show up for their trial to determine or to assist in setting what is their bond?
They do use a pretrial release score, and it's a number that they use. And in my experience in that particular courtroom doing that, they don't always have it done for a number of reasons, timing issues, and there's no conversation around it. They do an assessment that's pretty minimal, and they shout out a number. Pretrial score is 5, and then the judge, it assigns a bond more or less based off of what the county attorney is asking for. Is kind of how it goes, and that's on the felonies. As far as I know, that there's not a pretrial score on misdemeanors.
So I know that the studies reflect that if you don't have an objective measure, that people of color are going under the very same circumstances as a white person end up with a higher bond if you're not using an objective measure or an objective risk assessment.
Right. And I would, add on to that, even if you have an objective risk assessment and you're not forced to actually use it and have it reflected in your bond, then it doesn't do you any good either.
So I had a conversation, and I know we got the introducer here and we're spending a lot of time with you, but you do have experience in this. I had a meeting probably 2 years ago with Mike Meyer, who is now the head of Douglas County Corrections. At the time, at one time, Foxhall was the head of the corrections, and Meyer was in charge of trying to implement an objective measure or a risk assessment and get the judges in Douglas County to recognize it as a valid instrument and use it for setting bonds. Were you around during that time period?
That transition probably happened within the time I spent a lot less time in court, I would say.
I'm sorry, I'm having trouble here.
In the last year, that's been more in the last year where they were working on that. I think the last year and a half, and I hadn't been there as much in that time frame. I'm familiar with what you're talking about, but I'm trying to think I don't think I've been in that courtroom in that time frame.
So when they do these risk assessments, it's not just about how much money should it be set at, but is there something besides money that will keep a guy with this score coming back to court? And that may be a phone call every day. It might be an email reminder. It might be an ankle monitor. There are a lot of different ways to ensure somebody will show up besides setting a cash bail.
Yes, and we currently do have ability to do a lot of those things that you're talking about. It's kind of what you're getting at. The problem that I have seen, and that I think a lot of other people have seen, is we have used a yes and approach, where we introduced 24/7, which is a fantastic program, and started putting people on it, and then they started adding it as a condition on top of a cash bond, as opposed to releasing people on just on a 24/7 check-in. And so we have some of these tools that we're talking about, but a lot of people are still not being able to gain access to them and the benefit because they're still not able to post the cash bond that is being required in addition to that level of supervised release.
Do you see cash bonds having a disproportionate effect on communities of color?
Yes, certainly. It's hard to differentiate how the cash bonds are having a disproportionate effect and the criminal justice system as a whole is having a disproportionate effect. The criminal justice system where I practice in Douglas County is wildly disproportionate the number of people of each race is not representative of there. And I don't have the numbers in front of me, but it is anecdotally, I can tell you, disproportionately black and brown people who are coming through the criminal justice system in Douglas County. And they are then also disproportionately being incarcerated. I don't know if I could tell you whether or not the bonds were reflective, were proportionately disproportionate, I guess.
Okay. I think that's all we have for you at this time, but we'll look forward to the proponents and the opponents' testimony. With that, we'll take the first proponent. Good afternoon.
Good afternoon, Chairman Lathrop and other members of the committee. My name is George Dungan. It's Georgedungan. I'm a felony attorney at the Lancaster County Public Defender's Office. I'm also here today on behalf of the Nebraska Criminal Defense Attorneys Association. I'm here today to testify in favor of this bill as a proponent. I'm not really here to be speaking about the why this is important. There's a number of other people who will be here to testify about the why. I'm here today to talk a little bit more about the how. I was one of a few people that actually worked on the drafting of the language in the current iteration of this bill. And so I wanted to make sure that I could be here to answer any questions or talk about a couple of things. First of all, the flow chart, the process and procedure for how this works for those who might be unfamiliar with the system as it currently stands and what this would modify. And then also to speak to the constitutionality, as I believe Senator Pansing Brooks brought up from that testimony. I'm happy to speak about that. When I inevitably run out of time, I'm happy to answer questions regarding that as well. The way this bill is currently this proposed bill, the way it's currently set up, an individual would be arrested. They would then be taken before a judge. What's written in here is a presumption for a personal recognizance bond, as Senator Cavanaugh was just talking about. So there's a presumption that that individual shall be released on their own recognizance. Taking into consideration various factors that are outlined and specifically put into the proposed legislation, the court has to make a determination as to whether or not they think that release on a personal recognizance bond is sufficient. If they find, based on those things that they're considering, that it's not sufficient, the court then, next step is they have to consider what essentially we're calling a conditional release. That would be very much akin to the conditional release that people of this committee might be familiar with in juvenile court. That is a determination right then and there based on circumstances, again, that I'll get to in a second, that are outlined in the legislation, about whether or not there are certain conditions that can be imposed that would help assure either community safety or that individual's return to court. Those conditions that can be imposed at the time would be a monitor, no alcohol provisions, not leaving the state, things such as that. If the court makes the determination based on those factors that neither personal recognizance nor conditional release are sufficient, the bill then requires that the court shall, first of all, make written findings and specific findings as to why they don't believe the individual can be released on either of those, and then shall also appoint counsel if they don't already have that, and also shall order a screening. And that's the screening that Senator Cavanaugh was speaking about, a screening that then determines, based on a risk and needs assessment, whether or not that individual can or should be released back into the community. That result from that is then sent to the counsel that was either appointed or that individual was able to hire. And upon receipt of that screening, that individual can then, the defendant can then request a bond review based on that screening to determine whether or not there is a set of conditions that can be suggested to the court to create a further conditional release with community correction supervision. I see that I'm out of time here. I certainly don't want to go over my time, but I'm happy to answer questions about that process, procedure, or the constitutionality.
Senator Geist.
On the process, I'm curious when this individual would be diverted down the pathway of the screening that you were just speaking of. What is the time frame that you're talking about there?
I think there's not a set time frame specifically laid out in the bill. And the reason for that, I think, is twofold. This bill made great efforts to not use a one-size-fits-all for all of the counties and all the communities. Nebraska has a wide array of needs. You look at Douglas County versus Lancaster County, where I practice, versus Western Nebraska. Every county is going to have different needs. So each county is permitted by this to have their district courts and their county board designate a screening tool and a screening service that is used to determine whether or not those individuals then could be screened and subsequently released. Depending on the people that are available for that, the staff that are on hand, that could take place overnight. It could maybe take place in a week. Again, I think it is problematic when you're dealing with such a wide state to mandate that it happen in a certain amount of time. Certainly, I don't want people to be sitting there for too long, but you want to make sure that there's flexibility there. So upon that screening happening then, the idea is that would be expedited at all due speed to make sure that they can actually get that screening tool done into the hands of defense counsel or the defendant if they're representing themselves, so that way that individual can look at the result, talk to whatever that supervising entity might be, and determine whether or not there's a plan that they can put in place.
And then the screening tool, I'm curious, you said that would be up to the county to determine this tool. I'm curious if you go from county to county and you're treated differently, is that okay?
Certainly, I mean, there are certain requirements that are put in this about the kind of tool that would have to be used.
Okay.
So the tool that would be used has to be validated. And there's a number of factors in the proposed language that require it to be validated as to not discriminate based on race, based on gender, sexual orientation, sexual identity, class, those kind of factors, and it enumerates those.
Okay.
So the idea is that whatever tool is being used, even if the particular county has a slightly different tool, and I do think over time it would probably become similar. I know states tend to use one tool across the board generally, but the idea is that whatever tool is being used is validated, and that it would be validated in a way that would not result in disparate impact, depending on if you're in Cherry County versus Douglas County. The hope is that would still result in a similar release.
And that was my thought, so thank you.
Oh, I'm sorry, Senator Moorfield.
Thank you, Senator Lathrop. Thank you for coming today, Mr. Duncan. Can you talk a little bit about and I don't know which constitutional argument you're going to talk about, but the constitutional argument that I'm interested in, or not argument, constitutional issue that I'm interested in, is the one that's in the County Attorneys Association letter in opposition. And I'll state it very briefly. The Nebraska Constitution, Article 1, Section 9, states that all persons shall be bailable by sufficient sureties except for certain offenses where the proof is evident or the presumption great. Excessive bail shall not be required. Can you talk about how this doesn't run afoul of that?
Certainly, and that's an issue that's been raised, I think, before in talking about this. There's been comments or concerns that if we get rid of money bond as an entity, that doesn't satisfy the requirements of that anymore. I believe this bill is constitutional for a couple of reasons. One, specifically as part of the proposed language here, if you look at page 40, lines 12 through 14, it actually outlines a specific definition of bail. In our current statutes, there's not really a definition for bail or bond. Bail gets kind of thrown about as a legal colloquialism. But nationwide, there's a lot of conversation about the fact that bail doesn't necessarily just mean a monetary value that's posted. Bail is the process and the procedure through which an individual can be released, or is provided a set of circumstances then they can be released through. So we specifically define it here. Bail means the process by which a person is released from custody, either on his or her own recognizance or under conditions of release imposed by the court. So what I believe the Constitution does, or what it does with that language, it's saying that there's three, I believe, specific instances that an individual cannot be bailable. And that's treason, sex offenses that are involving force, and then murder. So what that does is it creates a very small subset of offenses wherein the court can say there is no bail, period. That's it, it's done. These are not bailable. You shall remain in here into perpetuity until the case is done. For all other offenses, it says that the individuals must be bailable. Bailable means that the option for bail exists. Under our current system, as it is there, and I believe Senator Cavanaugh spoke very eloquently about this, just because somebody's bailable doesn't mean that, as it currently stands, they get to get out whenever they want. As it currently stands, somebody is getting arraigned when I'm working arraignments in county court, and they say, "Judge, I can't post that bond." And the judge asks, "Okay, well, how much money do you have to post?" And the individual says, "I have $100." And the judge says, "Okay, that'll be $5,000, 10%. In that circumstance, they're not bailable. They can't get out. And so I think that under this proposed legislation, with the definition of bail being a set of conditions, what we're doing is presenting a list of conditions that trigger the bail. If at the end of this flow chart that I've kind of discussed, a person gets that assessment and it says, here's the kind of things that would need to be in place in order for you to be released, and they go in for a bond review and they propose that to the court, and the judge says, no, based on all the factors I've considered, I don't think you can be released. The individual is still permitted to come before the court for a further bond review and propose an additional plan. They could say, okay, judge, well, we know the last plan didn't work, but this time I've gotten signed up for treatment, I've already been accepted into treatment, how about now? So that individual is bailable. It just doesn't mean they're permitted to be bailed right there whenever they want. And so I do believe with the definition of bail as it's laid out in 636, as well as the way the system currently works, those individuals would be bailable.
Okay. And then, okay, I think I'm done with questions. I might ask off the mic later. Thank you.
Senator Pansy.
Yeah, thank you. Just quickly, you were going to talk about the testimony that, I'm just trying to remember what, I had asked something to Senator Cavanaugh. Do you remember the question?
I think it was actually very similar to what Mr. Moorfeld had just brought up, which, or Senator Moorfeld, sorry, was the constitutionality. I think that's what you would ask Senator Cavanaugh, that he deferred for a further testifier. And I'm happy to go into more detail about that.
No, you talked about the public safety claim too.
I'm sorry, could you say that again?
The public safety claim?
Certainly, yeah. I think that, and Senator Cavanaugh spoke to this, and I don't have numbers in front of me, but as it currently stands, part of the problem here, I think, that we're seeing in our current system is that the court is instructed to take into consideration certain factors, such as public safety and failing to appear and whether or not an individual is going to return to court. In the current system, if a judge wants to keep an individual in custody, they can simply say, I considered those factors, and no, we're not going to let you out. What this proposed language attempts to do in an effort to sort of tailor that a little bit more is to give them specific shall consider language and shall not consider language, and that's where the specific and written findings come into play, in an effort to make it more transparent for a defendant to know exactly why the court is denying that rather than simply reading the language of the statute. And so I think that addresses some of that public safety concern. For example, there are certain things that must be considered, such as ongoing needs for medical care, enrollment in educational programs, and involvement with community supports. And then there's certain things that must not be considered, such as allegations of failure to appear for court that occurred more than 2 years ago and that did not result in a conviction, or a history of criminal charges that are different in nature to the pending charges of what's before the court. So I think what this does is it tries to certainly take into consideration public safety. And I think that this does a better job of considering public safety than what we currently have. As of right now, as Senator Cavanaugh said, an individual who has the money can get out with no determination of public safety. If, however, something such as a validated risk assessment tool is utilized, that gives an actual number or scale that a court can look at to determine whether or not public safety is actually at risk by that individual re-entering the community. And I think that's a more data-driven approach, and I think that results in individuals who are not safety risks being released.
Okay, and just one other thing. So it's my understanding that across the country, that, I'm sorry, I'll leave this off, that courts are finding the debtor's prison system unconstitutional. So if that is happening across the country, wouldn't it seem like a bill like this could help, mitigate litigation risks and, just also save property tax dollars for individuals? Hello?
Absolutely.
Hello, property tax people.
No, I absolutely agree with that. I think that, and I believe Mr. Nigro is going to testify later about some of that. There have been suits that have been brought against counties and jurisdictions regarding their bail bond system, saying that it is in fact unconstitutional. And so it does, I think, create a mitigation of litigation risk by addressing it now. Certainly, I think as to those cost savings, it's incredibly important to keep in mind, and I don't know if the numbers for this, but there have been studies that show individuals who are out of custody at the time that they are sentenced are less likely to be sentenced to time in custody. So if we here in Nebraska have a concern that there are, for example, prisons being filled up at too high a rate or that we're getting overcrowding in prisons, one of many ways that we can address that is by ensuring that individuals have services in place while they're out of custody pending the resolution of a criminal case. That tends to make it more likely that a court will consider something like probation in an effort to continue to allow them to work through those services, which on the back end, I think does result in cost savings for the state as well.
Thank you.
Okay, thank you.
Thank you.
Next proponent. How many people are here to testify as a proponent? Okay, well, we just burned a good deal of the half hour, so I'm just making that point to the committee. Welcome.
Thank you. Mr. Chairman, members of the committee, I'm Joe Nigro, Joenigro. I'm the Lancaster County Public Defender. I appear on behalf of the Nebraska Criminal Defense Attorneys Association in my office in support of LB636. I want to thank Senator Cavanaugh for introducing this bill. When someone first appears in court on a criminal charge, the court sets a bond. If the person can post that bond, they are released while the case is pending. If they cannot post the bond, they will remain in custody. The purpose of bond dates back to Anglo-Saxon England and was to assure someone's appearance in court. That was the only purpose of bond in Nebraska until Senator Chambers left the legislature for the first time, and then safety of the community was added as a factor. People charged with crimes are presumed innocent, but if they cannot make bond, they sit in jail for however long it takes to resolve their case. Many of us don't have to worry about losing our jobs if we miss a day of work, but many of the people we represent will lose their job if they miss a shift. Then they lose their housing and their children can be placed in foster care. Time in jail can be devastating, and this is for people who are presumed innocent. LB 636 would eliminate the money bond system and replace it with a system of risk assessment, screening, and pretrial supervision for those who need it. Across the nation, people have realized that detaining people based upon how much money they have is immoral. There has been successful litigation challenging the money bond system in New Orleans, Houston, and California, among other places. The research is clear that people in custody are more likely to be convicted, often because they will plead to get their case over with, and they are sentenced more harshly. Lancaster County is 4% black, but 30% of the people in our jail are black. This is an issue of racial justice. Several states are reforming their bond systems. The District of Columbia stopped using money bond years ago. Over 90% of the people there are released from jail, and 90% return to court without committing other offenses. They have a good system of pretrial supervision. New Jersey drastically reduced the use of money bonds 6 years ago. The number of people in jail awaiting trial was significantly reduced, and the percentage of people returning to court changed little, and there was little change in the number of those who have been released committing other offenses. New Jersey and other states use the public safety assessment, an easily administered tool to determine if someone should be released. Illinois just ended the use of money bond in the last few weeks. Major reform. Opponents may try to scare you with stories of someone out on bond committing a crime. That just makes the case for a system of assessment and supervision to determine who should be released and how much supervision they need. The current system does not work. Prosecutors ask for high bond to show they think it's a serious case, and judges frequently go along with those recommendations. The amount set is not to let the person out, but to keep them in jail. Having money does not mean you are more likely to come back to court or are less of a risk to the community. It just means you have money. This system of jailing the poor is immoral and racist, and I urge the committee to advance LB 636. And I'm happy to address any questions about how this works in other states, what's happened in Illinois here quite recently, and the points in the county attorney's letter if anybody has questions.
Okay. Well, I don't see any questions.
I'll ask one brief one, because I want to make sure all the other testifiers are
Okay,
sure.
Senator Moorfield.
Thank you, Senator Lathrop. When they said the number of the individuals who will fail to appear for court under this proposal will far exceed the tens of thousands that are currently on warrant and need that part of the letter?
Well, that's just completely wrong. Because District of Columbia started cutting back on money bond in the 1960s. I mean, their system works. Over 90% of the people come back to court and they don't get in trouble. New Jersey, the same thing. Brooklyn and the Bronx have bail funds where they post bonds for people, and people come back at like a 96, 98% rate. So this idea that we're going to get rid of money bond and everybody's going to fail to appear is nonsense.
Okay. Thank you very much, Mr. Mayor.
Just quickly, Mr. Nigro, thank you for being here. What about the argument that it's going to cost so much money to warehouse poor people?
Well, the places that have reformed the system have incarcerated fewer people.
To the county, sorry.
Well, it costs Lancaster County $110 a day to house somebody. The cost for community corrections to supervise people is far, far less. So if we had the same kinds of reductions in our jail population as District of Columbia or New Jersey, we're going to release hundreds of people, and a felony case takes months and months. So you're talking about saving hundreds of thousands, if not millions of dollars, and you're going to get better. I mean, people under pretrial release supervision can get into treatment and programming that actually improves community safety. I know Senator Brandt had a question about people being in jail on a minor offense, and I have a personal example of somebody that came up to me at the Project Connect, the homeless event at the Pinnacle Arena, and wanted to tell a story about how he'd been arrested for trespassing. He was new in town, and he went to jail, and he thought it wasn't posted where he was, and so he wanted to contest the charge. The bond was a $1,000 percentage bond. He didn't realize he could ask for bond review, and he didn't realize he could ask for an attorney. He sat in jail for 36 days, and then when he got to court, he just decided to plead. He got a $50 fine. 36 days at about $100 a day for somebody who might have had a good defense. If he's able to get out, then he can come back and challenge it. But that's an example, I think, of how wrong the system is now.
Okay,
Thank you.
thanks.
You're welcome.
Good afternoon.
Hi, thank you for having me. My name is Karina McCormick, PhD, CARINA, MCCORMICK. This is my first time testifying in person during this session due to COVID, but I thought that this was really important. And I also noticed how ambitious this bill is, so I really wanted to come put my thoughts behind it and also advocate for continued effort towards this. I'm going to make some other points shortly, but I'd like to start with a story of something that happened to me a couple years ago and how it relates to bail bond, and this is actually how I came to know a lot of what I do know about it. I live just down the street. It's across from the soup kitchen, and one of the customers at the soup kitchen put me in a situation where I was very unsafe. Very reasonable concern for my safety, and of course I had the police come arrest him, and I did want him put away. They knew he didn't have any money, and so they were saying, oh, don't worry, he won't get out because he won't have the money for bail. But that didn't really make me feel better, because if he was going to be in jail, I wanted him to be in jail for what he did, or I wanted him to be sentenced for what he did. And if he was going to be held, I wanted it to be because the judge recognized he was making me unsafe. It wasn't very satisfying to me that the reason he was in jail and the reason he was being held is just because he didn't have $100 because he was homeless. And if he had somehow had some brother, some best friend who happened to give him $100, I would have been made unsafe. And this current law works so much better because the reason he's in jail would have been related to the causes that are laid out in this new proposal, not the fact of whether or not he happened to have $100. And by the time he finally did get the hearing, of course he was found guilty. There was evidence of what he did, but there was barely any of his sentence left. And so that as a victim of a crime, that was actually really anticlimactic for me, because I felt like actually the entire time he'd been in prison was not because of what he did to me, but because he didn't have $100. And I actually ended up feeling almost like I didn't have justice, as the fact that so much of his sentence was only the amount of time before his trial, not after any time that he was found guilty. And well, I know I don't have that much time left actually, but I think it was Senator Lathrop had asked a question to Senator Cavanaugh, who said, do you see having a cash bond as having a disproportionate effect on people of color? And that is not anything like an opinion. That's very clear cut that it does. And you had asked about if the amounts applied are disproportionate, but I would say that even if the amounts applied are equivalent or the exact same dollar amount, that doesn't have the same effect on different people. $100 doesn't mean anything to me. There's nothing in my life that depends on whether or not I have $100. But for these people, $100 is whether or not they can feed their family or pay rent or any of this. And because of that, I think it needs to be eliminated, because we do fully need equality before the law.
Okay. Thanks for coming down. Yeah, we're glad to hear from you.
Good afternoon, Judiciary Committee Chairperson Lathrop. It's been a minute. My name is Jasmine Harris, JASMINEHARRIS. I am the Director of Public Policy and Advocacy for RISE. We are here in support today of LB636 and ask that the committee moves it to general file. While we do serve 7 of the 10 Nebraska correctional facilities with our program, we understand that the alleviation of overcrowding needs to happen on the front end of our criminal justice system. We're looking at it from a proactive standpoint. Nebraska has a higher rate than countries of how many people we incarcerate, countries like UK, Canada, and Italy. And I'll bypass a lot of the numbers, but what we don't take into consideration is the transient population that is in and out of our county corrections where they see that overcrowdedness. The state's pretrial system needs an overhaul, just like the prison system does. One particular component is this cash bail, and it plays a role in the overcrowdedness. And we continue to hear over and over again how, like, Douglas County is the most overcrowded county jail. They're the #1 provider of mental health services, and we have to start addressing it from that standpoint. The average bond across the United States for a felony is $10,000. So that means here in Nebraska, people would have to come up with $1,000 to get out. That is not realistic for majority of people, especially when we're having high rates of poverty. People don't have indiscretionable income sitting aside where they can even post the $500 that we hear are a lot of people that are sitting in Douglas County Corrections. I do have the privilege of serving on a pretrial task force right now, and a lot of the things that we're looking at are the PSA assessment and a pilot program and things like that, and how we can get that across the state. It is trying to do away with the bias, which are in a lot of the risk assessments that we know have that racial bias in there. So trying to come up with a tool that has been validated that is going to help achieve that issue. As part of my work with RISE, I've conducted an assessment on the pretrial system last year. We had about 27 people who responded, and I'll email that. I did not want to print out 15 pages of stuff for everybody to kill more trees. But the results that I really wanted to talk about was that majority of people who answered it did not understand how the pretrial system or the statutes in our state works when it comes to detention. Majority stated that law enforcement does not divert people who have offenses that are stemming from social and behavioral needs. They do not issue citations in lieu of arrest, and a resounding 78% of respondents disagreed with the statement that no one is detained due to the inability to pay. What we see is that in these places like DC and other states, they have put things in place that include the risk assessment, that include programs that are court reminders for calling and texting people, and they have shown that people have showed up to their court appearances, and those are the pretrial services, so connecting them to substance use and mental health services. So again, letting them out on that, though they're showing this by other ways of things that they've implemented. And again, one of the other things is it only takes 3 days before someone is going to lose their job, their rights to their children, or the housing that they're serving in the correctional counties, jails on cash bail bonds. And what we have to do, ACLU of Nebraska had a report, and I think Spike can speak to it. An average here in Nebraska is 48 days that people spend in jail. So with that, I am open for any questions, and thank you.
I don't see any questions. I want to, as always, thank you for the work you do with RISE and what you do for the guys that are incarcerated. It's really impressive. I hope to get members of the committee in to see and to take some tours, but also to see your program in action inside.
Thank you.
Absolutely.
Yeah.
Have one.
Thank you. Senator Pansing-Brooks.
Sorry, what was the statistic? 4 days is the average?
3 days. Or 48.
Days till they lose, but
48 days average here in Nebraska that people are
48.
spending.
Okay, thank you.
Okay. Thank you. We'll take one last proponent and then go to opponent testimony.
Good evening, members of the committee. My name is Spike Eichholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska in support of the LB636. You've heard all of the reasons why this bill is an important bill and what it does, so I'm not going to repeat that, but I'll try to maybe pick up some points that maybe other didn't highlight, or maybe I didn't actually hear them say. The current system is demonstrably discriminatory against people of color. It just is. I would submit, without even confirming, that since we've had the money bond system in the state, it's always been disproportionate against people of color. When we did our study, the ACLU did our report in 2016, we looked at the 4 largest counties in the state: Hall, Sarpy, Lancaster, and Douglas County. And at that time, the majority of those people were in pretrial detention. And at that time, almost 6 in 10 were people of color. That's a majority, a simple majority, and it's certainly overrepresentation of the people of color in the state of Nebraska. Part of it is because there are more people of color who are poor. The money system now, the bond system, hurts people who are poor. It slows down people who've got money, and it doesn't really have anything to do with public safety, I would submit. The opponents argue, and I think the county attorneys argue, this assumption that people have that if you make someone post money, that's going to make them more safe if they get out. And I just don't think that's a sound assumption. And I'll just leave it at that. A couple of things. As far as a presumption of release for minor offenses, that's workable. You know, we've been arguing this issue, or some of us have been arguing this issue in front of this committee for a few years. And one of the arguments that we had that we made explicitly and sometimes implicitly was for these minor offenses, don't arrest, cite, and release. And the opponent's position was, can't do that. How's that going to work? They're not going to come to court. Last summer, that's what the major cities did. They moved to a cite and release. And that's, you saw a drop in both Lancaster and Douglas County's population, so it can work. I don't know what the county attorneys are claiming with the thousands of warrants now pending, if they are counting failed to pay warrants. I know that they have deliberately, with cooperation of the judges in Lancaster County, not pursued warrants because of COVID. And I don't think that has anything to do with what this bill proposes or what the bond does. And if it somehow is a problem, well, that's an indictment of the money bond system. Right? If people aren't coming to court under the current system, I don't see how this bill has any sort of, has to answer for that. I just want to also remind you, we're talking about people who are charged. They are presumed innocent. And for the reasons that Senator Cavanaugh said before, people, they may not be completely factually innocent, but they often have legal defenses. They waive and they concede simply because they cannot afford to be released. And it has demonstrably better outcomes if you're out on bond. I've got people who I represent private hire, they got money, they can get a drug and alcohol evaluation, they can keep their job, they can do those things that when they finally are found guilty of something, the judge is assured that they're going to be able to walk out that courtroom door and do something right. And if they're locked up in shackles after serving 60 days, that doesn't have the same assurance. I'll answer any questions if anyone has any.
Any questions for Mr. Eichholt? I don't see any. Thanks for being here. We will now take opponent testimony. Welcome back. I thought we were just going to see you once today.
Well, we'll try to make this painless as possible.
No, that's okay. We're glad to have you here.
Thank you, Chairman Lathrop, members of the Judiciary Committee. My name is Bruce Farrell. It's Ferrell, Chief of Police for the City of Wahoo and Second Vice President for the Chiefs Association. PCAM believes that the current bail system within the state of Nebraska is working. Bond reform has already been enacted last year with LB 881. Courts are being responsible in identifying persons, which is important, who are flight risks, have no ties to the jurisdiction, have committed a crime of violence, or are repeat offenders where cash bail or no bail may be required. The court currently also sets standardized nominal 10% bail amounts for all misdemeanors in the state, and those for those initially arrested in bond reviews, many times reduced to personal recognizance amounts within just a few days. In Saunders County, most misdemeanors and almost all nonviolent felonies have PR bonds currently that are modified after initial arrest or at the time that they were jailed and the initial appearance affidavit is submitted by the officers, which may also include drug court, drug rehabilitation, other types of modified release without cash bail. Law enforcement has also been using common sense in writing citations in lieu of booking for misdemeanors and nonviolent felonies. Even with those factors, we see tens of thousands of people that are currently under warrant for failure to appear in the state. Currently, the last time I looked, between 20 and 25,000 misdemeanor and felony warrants for arrest just in the county of Douglas County. Again, are those some that are fines that were not paid? Yes, they are, but there's still a significant amount of failure to appears within that set amount of money. In New York State, bail reform was passed in 2019. NYPD provided statistical information that in the first 2 months of 2020, crime was up 22.5%. In that same period, 482 persons previously arrested and released on bond with no cash bail went on to commit 846 new crimes. In the Loyola University study, which looked at felony bail reform under GO 18.18a in the state of Cook County, Illinois, found that 77% of defendants were released prior to the bond reform, 81% after it was instituted in Cook County. The study also, so they did have an increase in people released. The study also found that 17% failed to appear prior to that bond reform, and the number grew to 20% after bond reform. Additionally, in-depth look at the Loyola study found that there are issues with the methodology as well. In an article in the February 2021 City Journal, they found that 9,200 individuals that were released under the new bail reform were reoffended with 1,573 new crimes, of which 294 were violent. The University of Utah in February 2020 reevaluated the Loyola study. After looking at the statistical anomalies from the LU study, researchers, including a U.S. District Court judge, found that persons charged with new crimes rose 45%, and persons on pretrial release increased 33% in violent crimes. And even with those numbers, the state of Illinois chose to go further on bail reform. Again, we find that particularly the gun crimes in Chicago have increased over the last decade, and we find not only is it a concern, but for the release of bail under those conditions we have in Nebraska, but also the ones we have to also remember the victims of those crimes when it comes to bail reform as well. So with that, I'll take any questions.
Senator McKinney.
Thank you. If the current system is working, why is it so that 5 in 10 individuals held in county jails awaiting pretrial are people of color?
The only thing I can tell you, Senator McKinney, is that Douglas County has a risk assessment tool that they use at both bond setting and for bond reviews. They also look at those 4 identifiers that I looked at. The risk assessments being for reoffending, warrant history, not being part of the jurisdiction, and looking at protection of the victim in the crime.
You still kind of in it. Why is that disproportion so high?
I can't tell you why. The tools are there. Now, if the judges aren't using those tools correctly, then that's something that we need to address with the judges. But the tools are there with the risk assessment and with the four qualifiers that would either cause for a cash bail or for no bail. And we do see that we have, and I've seen anecdotally a number in both in Saunders County and in Douglas County where we're seeing more and more PR bonds and more people being released than there were before.
Do you think it's fair for someone to sit in the county jail for 48 days or 60 days because they can't pay a $500 fine? Do you think that's fair?
A $500 fine or $500 bond?
Bond, yeah.
What's that?
Bond.
Again, the bond is set either as a misdemeanor by the state Supreme Court, so it's that way, or if it's set at a dollar amount, say let's just say for a felony, they take into account the risk factors I've already addressed plus the risk assessment.
I get what you're trying to say. What I'm saying is somebody is sitting in the county jail and they need $500 to be released. Because they don't have this $500, they lose their house. Probably hurt their family, lose their job, but it's because this whole $500. Do you think that's fair in the current system? Do you think that's fair for somebody to lose a job, a home, and family in 48 days because they cannot afford to pay the $500 to be released? Do you think that's fair, yes or no?
I don't know that I can say if it's fair or not. What I can say is the bond is set based on those factors, the risk assessment and if there's any of those disqualifiers. If someone has a warrant history where they're not showing up for court, the safety of the victim is at risk based on and what the judges determine. Is that a fair bond? That's what the judge determined.
But it's not always a victim in those situations. I know you're referring to a victim situation, but there's victimless. There's crimes where there is no victim, and people are still sitting in the county jail.
Okay, well, let's just pick driving during suspension. It's a set bond by the state court. I believe it's $2,500. They need $250 to get out. They go before the court. Many times the court will release them on their own recognizance unless they are disqualified based on, and they may even set a higher bond based on those disqualifiers or the risk assessment.
Thank you.
Senator Pansy Brooks.
Thank you. Thank you for being here, Chief Farrell. From my limited interaction with you, I know you to be a compassionate, good guy, and I just cannot believe you think it's appropriate that people that are poor would lose their home, their jobs, everything because of $500. And if it were on the opposite end for somebody who's really wealthy, we'd be up at like $5 million or something like that. So and then everybody in the whole state would be rising up saying, this isn't fair, we shouldn't be doing this. We can't hold our upstanding citizens in. But because they're people of color and poor people, they're disposable people in most people's minds.
Well, I don't believe that at all, Senator.
I know
What I think is that the system that we have takes into account a number of factors. Now, if there's a risk assessment tool that can be studied to see if that's more effective in a pilot, then certainly we would be in favor of looking at that because, again, we want it to be fair, but we have to also be fair to our victims. And the majority of the people, again, from my own personal experience, is that are held on higher cash bonds usually meet those four disqualifiers. The other issue is we also look, anecdotally, we're seeing in some of our, let's just take with our juvenile justice reforms. In Douglas County, we're seeing a number of kids who are not eligible any longer to be detained in the juvenile detention center, who are on monitors, who have trackers, who are still going out and committing violent crimes like robbery, carjacking, felony assaults, drive-by shootings, even while they're on a bond, on a type of bond, where there's no consequences and they keep being released from that jail. So we have to find that happy medium, and I just don't know that without having a pilot program like it may be for Douglas County or Lancaster County to help point us the right way, if doing away with cash bond is going to be that that panacea that's going to change everything.
Do you think it helps to have, I mean, is it a panacea to take away somebody's livelihood and their, I mean, that's not a good solution, is to take away somebody's home, destroy their family for $500,
Well-
and then charge the county for all that.
Sure, and I heard on one time, the county supervisor, Boyle, talk in a radio interview one time, talking about how he had seen a person who was sentenced to a year in the jail because of a simple shoplifting. That never happens. It does not. Now, if they had 4 or 5 or 6 prior shoplifting convictions, I could see that. I don't believe that there is a concentrated effort, whether it's people of low income or people of color in the judicial, with our judges, to intentionally incarcerate them based on race or income intentionally. I think that when they look at the tools they've been given, which is the risk assessments, which took a long time for Douglas County to come up with, plus those other four disqualifiers, or those, I should say disqualifiers, the 4 areas where they may increase or cause for a cash bail, then those folks have the opportunity to continue to ask for bond review. And many times they do get bond review, and they are allowed to be released.
To me, it's clear, if we have this assessment, we're adding to the systemic racism that's obviously happening, here we go, right at the beginning of entry into the criminal justice system, something's wrong, and it isn't a good system, so.
And the only thing I'd say with that too is how are we to know that without having maybe an interim pilot program, that the risk assessment tool that's being applicated here in this bill won't also be systemically racist?
Thank you
I don't
for
know
coming,
that.
Chief. Thank you.
Senator Brandt.
Thank you, Chairman Lathrop. Thank you, Chief, for sticking it out today. So, Wahoo, Nebraska, what % of your time is spent chasing down bail jumpers, people that aren't showing up to court today? I mean, is that 10% of your police force time, 5%, 15%?
Usually what we're doing is we will actively go out and look for people, or we'll get calls for people that are on warrant. I can tell you that at our last investigators meeting in the county, I think I saw 3 pages, probably 30 to 40 persons per page that were warrants, from Saunders County. Again, they may not live here, but so we're talking about 120 to 150 people that were out on warrant.
And that would be from the county court? Or
That would be
district
county
court?
and district court.
And what % of those are still around? Do you,
That are still
in town, in county? Half?
At least half would still probably be in county, if not more. And it's just a matter of finding them, catching them at home, at work, driving the car.
So if we go to, overnight, we go to the new system, do you think those numbers would change for Saunders County?
I don't know. I can look at the numbers that the Loyola's University used for Cook County,
Yeah.
and they saw a, 4% or 3% increase in warrants for failure to appear.
Right.
And again, Cook County's pretty large, so 3% is a pretty good number.
Cook County and Saunders County are probably 2 different things.
Sure, but I'm just saying, I don't know what those numbers would look like. I don't know what they would look like in Douglas County.
And really, the judicial end of this needs to come here and represent, answer some of these questions, because you're sort of a victim of, you've got to chase these people down. You're not the one that sent them out.
Not only we're chasing them down, but we're also the ones that are making sure that we're trying to use good judgment in citing versus incarceration, and also occasionally making recommendations to the county attorney for people to get out for drug court, job placement, other types of alternative release. I make those recommendations on a fairly regular basis within the county court through the county attorneys.
Okay, thank you.
I got a few questions for you.
Sure.
How long do you keep a warrant active? So if I get a traffic ticket and I don't show up, a warrant is issued, you don't go look for me, you wait for me to get picked up again, right?
Well, we'll go look. It's whether we find you or not. But usually, I would say a good majority of the time, it's somebody gets stopped on a traffic stop, or somebody recognizes somebody and calls into Crime Stoppers, or we see them on the street walking by. So that's normally how they're picked up.
And
But
so
usually
how long do you keep those active?
Well,
So if
I think it's set
today,
statutorily as far as how long. I think we have 6 months or a year on a misdemeanor, and maybe 3 or 5 on a felony.
you will keep them active that long? So when you say there's tens of thousands, my question is that tens of thousands over 10 years that just pile up and they're sitting there unprocessed, or you haven't tracked the guy down that didn't show up?
When I worked for OPD, I know that they cleared as many warrants as they could, and I believe that after the statute of limitations, that some of those warrants are taken out of the system for those misdemeanors and those lower level felonies that disappear after 3 years.
Okay. So when you say tens of thousands, where's that come from? Is that the sum of years and years worth of warrants that remain outstanding?
Well, I mean, you'd have, if you had a homicide warrant, that's going to be
A whole different thing.
Whole different thing. But if it's
You're going looking for those guys.
Right, if it's let's say it's a shoplifting, felony shoplifting, if the statute of limitations is a year or 3 years, once that's over with, then that person, that warrant could be disposed of. And I've seen them dispose of those warrants because the statute of limitations runs out. But it's just a constant turning over. I mean, whether it's
Okay, but the
warrants.
You're the second person to say tens of thousands. I think we saw Bruce Prenda do that in a letter. So-
And I can only say that I know that there's at least 20 to 25,000 arrest warrants for either felony arrest warrants, for misdemeanor arrest warrants where we've sought the warrant, where people have failed to appear, and also who people own fines.
Okay, so
And the county might be able to give you that breakdown.
you repeated something that I have heard, not in this hearing, but in other hearings, which is we have juveniles who are released and they are out committing serious felonies. Do you have any data on the number of juveniles released in Douglas County in, say, the last 2 or 3 years that have committed a serious felony while released?
I'm sure we could get that number for you. I'd have to call either the county attorney's office or the juvenile county attorney's office to get those.
I'd be interested in that. Senator Geist has a bill to, I think it's 537, that deals with this subject. And when that bill was heard, we heard this, we got kids that are running around with ankle monitors on and shooting people. We made some changes in the law that were, I think Senator Pansy Brooks was involved in that were supposed to be best practices. I wasn't around for it, but those things were done. And Senator Geist's bill, I'm not trying to turn this into your hearing,
I'm
but
interested too.
Senator Geist's bill would in many ways roll a lot of that back. And I think some of the testimony we heard was, well, there's these kids running around that have been released and they're shooting people. I don't know if that's 2 people did it and now people want to change the law, or whether it is happening at an alarming rate, or are they isolated occurrences?
I'll try to find that out for you. I do remember.
I'd really like to know,
because I do know that there was a number of news reports and articles over the last year and a half where police chases, robberies, carjackings, drive-by shootings in Omaha specifically, where those persons, when the Omaha World Herald or the news organizations looked into their criminal history, found that they were on pretrial release and were not detained.
Right, and so if there's two of them that are really bad and one of these young people shoots somebody, then it's a big news story and it looks like a big problem. But if it's 10,000 kids that get released and one kid doesn't, then...
I do know in one instance there were 5 people involved in that series of crimes, and all 5, I believe, or 4 of the 5 were not detained at the juvenile detention center.
If you have information on that, and
Yeah,
this is
fine.
why I ask, after Senator Geist introduced her bill, I spoke with probation. My understanding is they're doing some validation to see if the risk assessment instrument and the process that was employed beginning a few years ago actually works or isn't working, or do we have a lot of young people that are not being detained that ought to be?
Sure.
Because we have a rash of them engaged in serious criminal activity. Right now, it feels a little anecdotal, like
Right.
we're getting a story, there's a thing in the paper, this kid did this. I'm not excusing any one of these people. Whenever we're talking about releasing people, whether it's from prison at the end of their sentence, putting them on parole, we're always trying to manage risk in the criminal justice system, and I'm trying to get a fix on whether we got a problem that is broad and quantifiable, or do we have some kids that have done awful things while they've been released, but they are isolated occurrences.
Sure. And I think the other thing that complicates things has been the COVID, because even though they have been given opportunities for whatever those release conditions are, probation's not doing drug testing. Probation isn't, or the trackers aren't out going and doing in-home visits. Probation isn't taking visits in their home. So again, it complicates that.
Well,
Gives people
that,
more
okay,
opportunity.
we're not turning this in, I guess I am
Yeah.
turning this into a 537 subsequent hearing, only because it's important that we are using, like, if we changed all the system, we changed the system and rolled back whatever best practices that were adopted during my term limited period, because COVID has kept the probation officers from going out to homes and doing the follow-up that this model sort of presupposes. That would be good information to know as well.
Sure.
I appreciate your,
And like I said,
your candor with respect to your
and I just
answer.
want you to understand too that we in law enforcement don't want to have people locked up just for the fun of it. I mean, normally if we make a recommendation to county attorney that somebody should be detained, it's usually for a pretty darn good reason. It's not because it's based on those risk factors that we already talked about. Because we want people to be able to have a job. We want them to be productive. We want them to take care of their families. So, again.
I appreciate that you're the chief of police in Wahoo and not in Omaha. But you sound like you still have a good deal of familiarity with what's going on in Omaha. And if you have information on that would help us understand, is this a COVID issue? Is probation unable to do the things that this model presupposes? All that's going to be helpful in assessing what do we do with these juveniles, what do we do with 537 moving forward. Senator Pansy Brooks.
Just for the record, I want to remind that the Chief Justice came and said that that the new best practices that have been implemented are working, that the numbers are going down. They're very pleased about what's going on. The other thing I wanted to mention is that in Lancaster County, the county attorneys there have had amnesty forgiveness events, amnesty and forgiveness events on warrants. So now to all of a sudden be talking about warrants as one of the main problems, I really find it disappointing. So
Well, and I think Douglas County's done some of the same. They've done amnesty as well. They've done a number of They've got some other restorative justice projects going on, and so do a number of other communities. In Saunders County, we've got a very progressive drug court. We have very few people locked up for drug offenses in Saunders County. I think we're all moving in the right direction. It's just making sure that the tool or the release factors that we're doing are going to be the ones that are going to be the right fit to keep the right people in jail that are the most dangerous to society versus penalizing people, again, like you said, just because they don't have $100 to get out of jail.
And I just wanted to say one more thing. There's a quote by a man named Ibram Kendi, the author of How to Be an Anti-Racist. And in that book, he said that you determine whether a system is racist by its outcome, not by the intent with which it was designed. So to say that the bond system isn't racist when 6 out of 10 are in county jails are African American or people of color, it doesn't matter what the intent was.
Well, and
the
I
system is racist.
And I agree to that, and I also think that we also have to look at what other factors like poverty, lack of business opportunities, all of those things play into all of that.
Yes, white, wealthy people do not spend their time in jail waiting for their trial.
And again, that's a poverty issue. Yeah.
Thank you.
Yeah.
Chief, thanks for being here once again. If you have any information you want to share, just shoot me an email or something.
Sure.
Yeah, thank you. Jim?
Neutral.
Oh, neutral. All right. Any other opponents? Seeing none, we'll take neutral testimony.
Chairman Lathrop, members of the Judiciary Committee, good afternoon. It's been a long day. My name is Jim McGuire, Jimmaguire. I'm president of the Nebraska Fraternal Order Police. I'm going to be testifying in a neutral capacity. I wasn't sure if I wanted to testify in opposition or neutral. I thought it would be better if it was just neutral. Just so everybody's clear, I've been a street cop in Omaha, Douglas County for over 29 years. So, my goodness, I don't know how many people I've had to run into where they've had warrants. I've worked at the courthouse, and the vast majority of the warrants, if you go down to the traffic court, you're probably going to have about 10 or 15 warrants every day for people just not showing up. So, do we think that everybody needs to be in jail? Absolutely not. We just need them to show up to court more than anything else. But the way that the bill is currently written is interesting at best. We think that it needs broader discussion the way it's currently read and just kind of work on some things. I will say this, even when I was working for Douglas County, now Omaha Police, it's pretty much told that if you pull somebody over and it's an arrestable offense, it needs to be, just write a citation. Write a citation at all costs. But if you get to the point where you can't write the citation, you have to take them to jail. And it's not the policy just to drive around and arrest people left and right. A lot of times what happens is that they'll have a warrant on file and you'll have something that you could have written them a citation for, but you can't. If you're gonna arrest them for the warrant, you're just gonna tack on the other charges so that it can all get done right then and there. So, the last thing we want to do is just see people in jail on minor offenses. We don't want to do it, but you're just kind of stuck having to do it because you may pull somebody over and may have 10 or 15 warrants, and it's going to stack up. But the only thing that we talk about people that are in there for pre-trial, I'd just be curious to see how many are in there on like a domestic violence case, because those bonds are going to be a lot higher and it's going to be harder for them to get out. But it's also meant to protect the victim so that they don't immediately get out, go back to the home and have more violence within that home. So there is, and I understand it's in the bill that it says with the risk assessment and everything else, but it's very complicated, and I would just Our position obviously is neutral, and it should be up for a broader discussion in between the two sessions. Thank you very much. I'd be happy to answer any questions if there are any.
Just one clarification.
Sure.
Are you here for the FOP or the OPOA, or what's your capacity today?
I'm going to say the FOP. The OPOA is FOP now, but I'm going to say because it affects everybody throughout the state when you talk about these no cash bails.
Okay.
I'll be there.
Okay. Any questions for Jim? I don't see any. Thanks for being here. Thanks for waiting as long as you had to.
Thank you.
I don't see any other testifiers in the room. So with that, we will have Senator Cavanaugh close on LB636. We do have 10 position letters. 5 of them are proponents. 4 of them are in opposition. 1 of them is neutral. And we have written testimony from 2 as follows. Bruce Prenda with the Nebraska County Attorneys Association is opposed, a letter that we've had some conversation about. John Cannon with NACO submitted testimony in the neutral capacity. Senator Cavanaugh, you may close.
Thank you, Chairman Lathrop, and thank you to the Judiciary Committee. This has been a very good discussion, and I appreciate everyone who came and testified actually on all sides. I particularly appreciate the testimony from Ms. McCormick and Ms. Harris, who came and gave us some perspective. And I also appreciated Chief, and I'm sorry, is it Farrell? I didn't quite, did he leave? Oh, he left. Oh, well, I didn't quite catch what his last name was, but Chief, and he made a couple of points that I thought were really kind of spoke to the necessity for this. And I think Senator Pansing Brooks hit on this, that there's no concerted effort to do this, to have a discriminatory effect. And we have made these reforms before that have created another structure for discretion in the hands of the judges, and it hasn't really made a difference in the outcomes. And if the outcomes are still the same, we're not doing enough. And so this is really, taking cash off the table is not, and I can't stress this enough, is not a situation that's going to release everyone. It's creating a situation where money is not the reason people are not released. There are other reasons and other things. And he also hit on, and so did Ms. McCormick, about the fact that the ability to pay does not respect the victim. That the part of the reason for how we detain people has to do with about how the concerns of the victim, the concerns and the respect for them, and this allows for a more respectful approach to that. I did especially want to thank Mr. McGuire for being here and for being in the neutral capacity, and I've spoken to him, I've spoken to a couple of other of his colleagues, and I've spoken to a few other people about people's concerns about this and things that we can work on to make it workable. But the takeaway I have from a lot of the conversation here is that there is a real necessity for a change in a system that is not working. And to answer Senator McKinney's question, it's not a fair system. It's if it were fair, if it were just, it would be easier to say that, but it's not. The outcomes are disproportionate, and they disproportionately affect Black and brown people, but they are, it also disproportionately affects poor people. And that, the justice system, the one thing I wrote down here to remind myself, when we are putting people's liberty at question, it's a serious responsibility that needs to be taken seriously. And we have become lazy when it comes to making that determination. We are falling back on a crutch to make that determination, and that is resulting in some bad outcomes. And we have a responsibility to make changes that are going to maybe be difficult, maybe make the system a little bit harder, and make a little bit more effort, but it will make it more just. And to Mr. McGuire and I have spent a good amount of time in the same rooms, being the Douglas County Criminal Traffic Court. And to answer that question, the 25,000 or whatever that number is exactly, just to put a little context to it, as he pointed out, some people have 15 warrants. That could be one person with a bunch of warrants. Those warrants could also be failure to pay warrants for a number of non-jailable offenses. You can look up, Douglas County Sheriff's Department has online, you can see every warrant, go look. I did a quick search, and literally the second person that I found on there, second from the top, was a 104-year-old man who has an outstanding failure to pay warrant for a no registration from 2013. That's the second one from the top. So out of those 25,000, how many of them are like that? How many of them are one person with a bunch of warrants? How many of them are failure to pays? And as for the failure to appear warrants that get issued in places like Douglas County Courthouse, I can tell you the number of times that someone got a failure to appear warrant when they had 9 a.m. court and they showed up at 9:05 and the judge was already done and they'd issued the warrants. Or they showed up at 1:30 or 1:40 and they had already finished 1:30 court. And then that person had to come back the next day to cancel that warrant. So not every one of these times when you see a failure to appear on somebody's record, you see a warrant, that is not necessarily a reflection of that person's unwillingness to show. It may have to do with a punctuality problem, but I don't think that that's what we're trying to address here. And so I think that I've addressed everything I wanted to address. I really do appreciate everybody's time at the end of a long week and a long session, and if you have any more questions, I'm happy to take them.
I don't see any. All right, Senator Cavanaugh, thanks for an interesting discussion on bail and introducing LB636. That will close our hearing on LB636 and close our hearing for the day. Everybody have a great 4-day weekend.